Okay, so Mr. Segura, when you were here and entered your plea of guilty, I asked you some very specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that of your version that I received here in the pre-sentence report is a little different. It says that you didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes, ma'am.
You drove to the Taco Bell.
I drove to the Taco Bell.
You stopped at the Taco Bell and you drank while your vehicle was stopped.
No, ma'am. I was outside the vehicle when the officer.
So you hung out at Taco Bell.
I was there
and drank.
I was waiting for the line to move so I could get my food.
I asked that the defendant be sworn.
Yeah. Let's do that. Raise your right hand. You
Yes.
swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay, so you're saying that you got to Taco Bell. You drove to Taco Bell,
Yes, ma'am.
okay?
I made a right turn with my signal and everything. Then I was about to park my vehicle.
Mhm.
That's where the swerve came in at. Okay, obviously it has to be. And then so,
I'm not worried about, let's,
Oh,
hold
yeah.
on.
yes, ma'am.
All right. I want to know, when you got to Taco Bell, regardless of whatever happened,
Right.
did you go through the drive-through or
No.
did you park?
No, ma'am. No, ma'am. I
Listen to
parked-
my question. Did you go through the drive-through or did you park?
I parked my
Okay,
car.
so when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle and see.
Buckle up, guys. Today we are going to watch this hearing explode into motion. Right away, the defendant offers a confusing Taco Bell timeline. Drive, park, drink, and the judge digs in. The back and forth about where and when he drank planched out. The oath and witness set up heightened stakes, and the audience senses the thread that will unravel the defendant's explanation. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judge's pivot and the subtle courtroom reactions. They reveal the case's true stakes.
How far traffic was up in front of me.
Okay,
They had several cars in front of me.
in front of you for what? You were parked.
Yeah, I was parked like,
Were you parked in a parking spot or were you
No,
parked in
ma'am.
the drive-through?
I was not exactly in the drive-through. I was at the end of the store. At the end of the store.
Okay,
But I guess you could consider that the drive-through line.
were you waiting for the drive-through?
I was waiting for the drive-through to
Okay,
proceed
listen,
because-
here's the thing. You're not going to try to trick me up with semantics
No,
today.
ma'am.
Hold on, don't talk over me.
Yes, ma'am.
When I say, were you going through the drive-through or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the
I was
drive-through?
actually waiting to go through the drive-through.
Okay. I may look, I don't know, like I'm 12 years old and just fell off the
No,
turnip
no,
truck,
ma'am.
but I'm not.
No, ma'am. I'm
So
not.
you're in the line and you get out of your vehicle, right? Because
Yes,
there's a long line, the
Right.
cars aren't moving.
right.
Right. So you get out and you decide, I'm going to start drinking here in the parking lot.
No, ma'am. I didn't drink until I got back inside my car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am.
So you're telling me that you started drinking at Taco Bell.
Yeah, I opened the container. That's how the beer came. It was on the floor.
So
of
from the
vehicle.
time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Maybe 15 to 20, 30 minutes, whatever.
Okay. How much did you drink between that time?
I had a malt liquor. The
Mhm.
211 is a strong beer.
Just one?
It was a 40 ounce.
Here the judge methodically dismantles the defendant's timeline. Pressed on blood alcohol logic, the court exposes glaring inconsistencies. One 40-ounce drink cannot plausibly produce the recorded BAC given the defendant's account. The judge's skepticism shifts tone from question to near certainty that the story doesn't hold, and courtroom pressure climbs. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judge's pivot and the subtle courtroom reactions. They reveal the case's true stakes.
Right. So you drank the whole 40
I was
ounces.
drinking out of the thing. After the fact that
You were drinking out of what?
after I stepped back in the car,
Mhm.
I started drinking.
Right.
And
So,
then- so
how much of it did you drink?
I consumed a lot of it,
Okay, so let's just say you drank most of
most of it.
one 40 ounce.
It was getting contained.
So that's your story and you're
I
sticking,
changed
hold
it.
on. So is that your story and you're sticking with it, that you drank most of one 40 ounce beer in about 15 to 30 minutes and that
Yeah.
you hadn't drank anything before then?
No, except for that night before, about 2 o'clock that morning. And
Okay.
then whole blood, alcohol stays in your blood system added to what I drank.
Okay, so your test on this night after drinking most of a 40 ounce was 0.188. And you're wanting me to believe that that's based on one.
The prosecution pivots to evidence. An expert witness is sworn in to establish identity and link prior judgments. This move turns the dispute into a technical showdown. Fingerprints, dates of birth, and documentary comparisons lend weight to the state's case. The expert's credentials and the oath give testimony credibility and shift the hearing from narrative to proof. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judges pivot and the subtle courtroom reactions. They reveal the case's true stakes.
Most of one drink, and that maybe you still had alcohol in your system from the day before.
Yes, ma'am,
Okay.
but what I recalling my memory, ma'am, I have no reason to try to trick you, Miss West. I'm telling you the God's honest truth. Like I said, I had alcohol in my system from the night before.
Well, how much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if
And
you had,
hold-
hang on, so if you had that much alcohol in your system from the night before, that you were still probably
wasn't. I
hold
wasn't.
on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood and you had just driven to the Taco Bell.
No, I drove into the Taco Bell that later on that evening,
You're not, right,
but it wasn't a full 24 hours,
right.
right?
So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Yes, ma'am.
Okay. All right. So let's go back. Obviously there's some medium acceptance of responsibility, so we can go forward with the arguments unagreed. Mr. Burbank, I'm sorry, Mr. Coleman, you have a witness?
Yes, Your Honor. State Cause Troy Robinson.
Mr. Robertson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Your Honor, the court's familiar with Mr. Robinson and his background, but for
Sure.
the purpose of the record, Mr. Robinson, you're certified as a fingerprint expert. Isn't that correct?
That's correct.
How long have you been certified as a fingerprint expert?
A heavy procedural beat follows as the state offers a summary of prior judgments tied to fingerprints and identifiers. Counsel spar about what's on the PSI versus what's new, while the judge probes duplications and admissibility. This segment frames potential enhancement exposure. Every prior on that list could drastically alter punishment. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judges pivot and the subtle courtroom reactions. They reveal the case's true stakes.
Almost 6 years now,
Testifying in court before.
multiple times.
You've had an opportunity to review some documentation in this case.
I have.
Did they include prior judgments for the defendant, Mark Anthony Segura?
They were.
I'm showing you what's been marked as State's Exhibit Number 1. Is State's Exhibit Number 1 a fair and accurate summary of the 20 previous felony judgments that you reviewed in this case?
It is.
Using your,
For 20 felony judgments.
I apologize, 20 previous prior criminal judgments, including a number of felonies.
Correct.
Okay, in other words, both misdemeanors and felonies.
Yes, sir.
And did you use the defendant's admission to at least one of the DWIs that he pled true to it had a print on its judgment to compare to the judgments here that had prints on it.
That is correct.
And what was your determination?
They're the same person.
And in addition to the prints that you used to compare and confirm his identity on these judgments, were there also some personal identifying information such as date of birth, SID numbers, and that kind of thing that you used to link to this?
Correct. As known identifiers.
Your Honor, at this time, I would offer State's Exhibit number 1, which is a summary of the judgments and the actual judgments themselves that are marked as State's Exhibits 2 through 20. For purposes of the record, tender to defense counsel.
Let me just ask, are there any on that list that aren't already on the pre-sentence report? I mean, why are we
It's
doing
been a while
both?
since I looked at the judge. I did think that there was at least a couple of those judgments. It's been a while since.
Mr. Burbank, does your client,
I'm gonna,
Counsel argue and the judge forces a crucial clarification. Which priors matter and which are duplicative? Defense objections target identification gaps while the state leans on the PSI. This legal jockeying is less flashy but decisive. Whether certain convictions count will determine sentencing exposure. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judge's pivot and the subtle courtroom reactions. They reveal the case's true stakes.
hold on, does your client have any objection or any reason not to, for me not to take judicial notice of the PSI for sure, that those prior offenses listed in there and the ones that are convictions are any way wrong?
for the misdemeanors, that's correct.
Okay, so what about for the felonies? Is there one, are there one or more that are contest?
It's a catch-22, Judge.
Okay.
Because he's pled not true to them so that you'd have the full range of punishment.
Oh, okay, so,
Yeah, so
So-
it's the two felonies that I think are crucial here.
all right, so then do you have any objection to the states, was it 1 and 2?
Judge, it's,
No.
State's 1 is a summary.
I object
And
to
then-
states 1 because I was not given the misdemeanors.
Okay, my main concern
It's
are
the
the felonies. And if you have the actual judgments on those, why don't we do that way, even though it might be a little more documentation, Mr. Coleman? If you will go through primarily the felonies would be my concern.
Yes, Judge.
And,
Here's where I'd like to do, Judge. I'd like to admit the summary and just the felonies as a backup, because what I want the court to refer to is the summary. I want to talk about the summary.
well, I want to talk about, I mean, I've got the pre-sentence report. So I need to know if there's something in the summary that's not in this report. That's what I'm kind of used to looking at. I've already made my notes on it. I've got highlights. So if there's something that's not on that already, let me know. If there is, then obviously I will. Are that there are 19.
Tension ratchets as the judge orders a recess so counsel can organize the enhancement list. That procedural pause signals complexity and consequence. The court demands a precise mapping of the 6 charged priors versus others to avoid duplicate treatment. This short break is dramatic in context. It's the calm before a legal storm where tiny evidentiary details will shape years behind bars. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judge's pivot and the subtle courtroom reactions. They reveal the case's true stakes.
Misdemeanor convictions on the pre-sentence report, and that I've got 8 felony convictions.
I think I don't have 8, Judge. I think that there's at least one of them that was refused. If you refer to the PSI, that first one, that burglary, looks like it was refused.
Stop, don't, let us figure it out.
Yes, ma'am.
So what I show with convictions on the PSI, I've got a 91 possession of a controlled substance. There was a probation that was revoked for 5 TDC.
Yes, Judge.
Got a 96 manufacturing delivery of a controlled substance, 1 year jail. I've got a 03 possession of a controlled substance, 18 months state jail.
I have that.
I've got an 03 from April manufacturer delivery with 6 months state jail. I've got a January of 15, obstruction or retaliation, 2 TDC.
Yes.
I've got at the same date, a harassment of a public servant, 2 TDC. I've got a driving while intoxicated, third or more. Offense date of 11 of 15, 3 TDC. And then I've got an 18 obstruction retaliation with 5 TDC. That totals 8 felony convictions.
That's more than what I had in my summary, Judge.
Okay. So are there then, I need at least whatever you have, because he has pled not true to the ones alleged in the indictment, which, let me pull that up.
Yes, Judge.
There's states 5.
May I elaborate?
He
Yeah.
needs to
Give him a
review his
second.
documentation.
The
So,
document's right there, state.
Hey, Mr. Burbank,
sorry,
you
Judge.
asked a question. Let him answer the question.
I
Calm down.
would.
When the hearing resumes, the judge begins taking judicial notice and announces the first prior felony finding is true. That formal declaration elevates background records into enforceable facts the court will use at sentencing. The judge explains the evidentiary basis carefully, and the room's energy shifts as momentum tilts toward increased punishment. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judge's pivot and the subtle courtroom reactions. They reveal the case's true stakes.
He's on it, I'm sure. Mr. Robinson?
yes, ma'am. So what I did is I took a known that he had pled true to. I used the fingerprint off of this known that was pled true to. And then I compared these documents to this document to the rest of these documents. Some of them have fingerprints, some of them do not have fingerprints. They, however, all have name, date of birth, identifiers of that nature, which is what I've compared to make these.
So in-
they're all true.
Does states 5 have the fingerprint? How did you,
I was going
do
through
states
that
five?
because several of them don't have the fingerprints, but
Okay.
there are a few that do.
go ahead. Let me also, let's kind of stop because there might be, right now, I told you to kind of focus in on the 3 that are in the indictment. The state did file a notice of intent to use prior convictions to enhance punishment back in January of this year of 2024. And so that motion lists it lists 6 felony offenses. So we obviously need to go through these 6 potentially as well.
Thanks.
Here's what I want to do. We're going to take I want to take a quick break. I'm going to take care of this other matter. Y'all go through, get it organized on the 6 that are in that motion. If any that are in that motion are not duplicative, I want to know which ones are duplicative of the ones in the indictment so that we're not talking about them twice. If there's 3 in the indictment and those are included in the motion, if some of them are, some of them aren't, be ready to tell me so I can know which ones we're going.
The court continues making findings, confirming multiple felony priors while excluding one for insufficient linkage. Each true finding tightens the defense's options and crystallizes enhancement exposure. The potential sentence range grows with every confirmed prior. This sequence is where legal reality overtakes mitigation efforts and the inevitability of a severe outcome becomes palpable. The exchange is precise, unforgiving, and every understatement hides legal consequence. Watch the judge's pivot and the subtle courtroom reactions. They reveal the case's true stakes.